criminal cases to be proved beyond reasonable doubt, establishment of the presence of eyewitnesses at the place of occurrence scope. The accused persons were convicted by the Sessions Court under Section 148 of IPC and sentenced them each to undergo simple imprisonment for 2 years with fine of rupees 500 and in default to undergo further simple imprisonment for 1 month and also convicted them under section 302/149 of IPC and sentenced them each to undergo life imprisonment with fine of rupees 2000 and in default to undergo simple imprisonment for 6 months. Aggrieved by this conviction and sentence, accused persons preferred appeal before the High Court, which dismissed the appeal. Challenging the same, accused persons preferred appeal before the Supreme Court. While allowing the appeal, the Supreme Court held that the High Court in the impugned judgment has concluded that the presence of PW 25 Mirza Majid Biag is established in view of the fact that his Maruti van was used for shifting injured to the hospital. There was nothing on record to show the Maruti vehicles used for transporting Ashok Kumar deceased to the hospital belonged to PW 25 Mirza Majid Beg. In fact, PW 19 Anil Kumar Jain in his cross examination has stated that he did not know the registration number of the Maruti van in which Ashok Kumar was taken to hospital, and he also did not know whose vehicles it was. In other words, nothing is established by the use of these Maruti vehicles for transporting to the injured to the hospital, and in any event, this will not clinch the presence of PW 25 Mirza Majid Beg at the time of occurrence. PW 25 Mirza Majid Beg and PW 24 Muhammad Sakir slipping away unnoticed by the others, particularly after the alleged attack, is utterly unbelievable. It appears unreal. They are not strange to expect, and they did not render any help for shifting the injured to the hospital, nor had the courtesy to go inside the hospital to ascertain the condition, and also did not inform the occurrence to the police. The aspect of fear is without any foundation and is not supported by any evidence of act or conduct. This plea does not impress us. In this context, it is relevant to point out that PW 25 Mirza Majid Beg has admitted that he is a history seeker, and 2 cases under NDPS Act were imposed on him, and he was also bound down under section 110 of the Code of Criminal Procedure. The statements of PW25 Mirza Mazid Beg and PW24 Muhammad Sakir were recorded after 3 days of the occurrence. No explanation is forthcoming as to why they are not examined for 3 days. It is also not known as to how the police came to know that these witnesses saw the occurrence. The delay in recording the statements casts a serious doubt about their being eyewitnesses to the occurrence. It may suggest that the investigating officer was deliberately marking time with a view to decide about the shape to be given to the case and the eyewitnesses to be introduced. The circumstances in this case lend such significance to this delay. PW25 Mirza Mazid Beg and PW24 Muhammad Sakir, in view of their unexplained silence and delayed statement to the police, does not appear to be wholly reliable witnesses. There is no corroboration of their evidence from any other independent source either. It is rather unsafe to rely upon their evidence only to uphold the conviction and sentence of the appellants. The High Court has failed to advert to the contentions raised by the appellants and reappreciate the evidence, thereby resulting in miscarriage of justice. The case against the appellants has not been approved beyond reasonable doubt.